Hello, everybody. My name is Aaron Cornejo, and my topic for my presentation is gun control, and specifically the case of the District of Columbia versus Heller. This case had to do with a special police officer named Dick Anthony Heller, who was not allowed to possess a gun in his home for personal safety due to a law that had been enacted in 1976, which was called the 1975 Firearms Control Regulations Act, that denied the right for any resident of the District of Columbia from possessing a gun. The law actually allowed the police chief to issue 1 year licenses, but required those who were issued the licenses to keep their guns unloaded, disassembled, and restrained by a trigger lock or some other form of security mechanism. Heller had requested a permit to keep a gun in his home. Heller sued the District of Columbia on grounds that the Second Amendment had been restricted. First, with a law prohibiting possession of a gun at his home, and then that the trigger lock mechanism would make his weapon not functionable. Heller initially lost his case in district court, with the district court dismissing his lawsuit. However, he appealed his case in the D.C. District Court of Appeals and he won, but the District of Columbia took it all the way to the Supreme Court. Heller alleged that this law, and in effect the District of Columbia, was denying him his Second Amendment rights to keep and bear arms. The District of Columbia issued that the Constitution had provisions, and in those provisions they had the right to regulate, and that the Second Amendment only had to do with the militia. The Supreme Court sided 5-4 with the D.C. District Court of Appeals and with Heller, establishing that the Second Amendment right wasn't unlimited, meaning they could restrict possession of a weapon by individuals such as felons or those who were mentally ill. The Supreme Court also stated that it was legal to forbid the possession of firearms in certain locations, such as schools and government buildings, as well as imposing the conditions of the commercial sale of firearms. The constitutional question here is whether Heller had a right to possess a firearm in his home, and whether the District of Columbia's law forbidding the possession of a firearm by anybody was constitutional. Our Constitution is an old document that has actually withstood its time. Our forefathers kept this Constitution flexible in order so that it could be interpreted over time, which is why our Supreme Court is so important. When our Constitution was written, firearms would take at least a minute to load one round and shoot. Range was very limited, and as we all know, accuracy was pretty atrocious. They didn't have rifles such as M16s which can fire off dozens of rounds a minute. The Supreme Court in its Heller decision would note that banning dangerous and unusual weapons was consistent with the Second Amendment. We have a federal government and states that are allowed to enact and implement their laws, just as long as they are not trumped by federal law. The District of Columbia, though not a state, is operated in the same way as that of the state. Their attempt to create a law restricting the possession of firearms, the registration of any new firearms, and mandating that any existing guns, rifles be disassembled or have them secured by some type of trigger lock mechanism was ultimately struck down by the Supreme Court's decision, meaning they were found to be unconstitutional. Even Heller, who was a special officer and through his appointment needed to be in possession of a handgun, was in violation of the law that had been enacted in the District of Columbia. He asked for a permit that he wanted to have a weapon in his home for self-defense, and that was denied. Now, the District of Columbia has actually had 8,100 people die through violence, especially in violence created by firearms, and that's been since 1976. So even though there was an attempt to curb the amount of firearms in the possession of people, the violence has still been the same. The amount of people dying has still been the same. This case actually went to the Supreme Court. The decision was handed down by the Supreme Court in 2008, and initially Heller did sue the District of Columbia in 2007. So from 1975 to 2008, 8,100 people died as a result of gun violence. Um, you could understand that the intentions were good as far as the District of Columbia trying to curb violence by trying to eliminate people from possessing guns. However, it I feel that what it did is actually restricted the people who were legally entitled and constitutionally entitled from possessing guns from having them. Those who are criminals and are going to commit crimes with these weapons, they don't care about following their law or not. They're going to do whatever they're going to do. So it was a good thing for Heller to have fought this, and I agree with Heller that we all need to have our Second Amendments protected. It's not necessarily that you can be in favor of owning a weapon or not owning a weapon. I think the Constitution gives us our rights, and we should make sure that those rights are never interrupted. Thank you.